There's a principle older than any courthouse, that property can't be taken from you without due process. A higher law has been tracking what happens when that principle meets a judge with, apparently, the gift of ESP.
Laura Lynn Hammett has been documenting a case in Arkansas that touches on prejudgment property seizure, judicial bias allegations, and what a guest analyst calls fraud upon the court. Let's start with the allegations against Judge Susan Weaver.
The core question here is whether a judge can effectively transfer someone's property before a final judgment, and whether appellate courts can simply look away when that happens.
The Post anchors itself to a 1991 Supreme Court ruling, and the quote goes directly to the constitutional standard. This case requires us to determine whether a state statute that authorizes prejudgment attachment of real estate without prior notice or hearing, without a showing of extraordinary circumstances, and without a requirement that the person seeking the attachment post a bond satisfies the due process clause of the 14th Amendment. We hold that, as applied to this case, it does not. That's Connecticut v. Doer.
So the constitutional floor has been established for over 30 years. No bond, no notice, no extraordinary circumstances shown means no valid attachment. The Post argues none of those conditions were met in Pietrak versus Rural Revival Living Trust, and the property moved into an irrevocable trust and sold to a third party before any final judgment issued.
Right, and the appellate layer compounds the concern. The Arkansas Court of Appeals, Judges Gruber, Thayer, and Harrison, dismissed for lack of jurisdiction, ruling the case wasn't final at the time of appeal. The Post points out the obvious tension. The property had already been transferred by then.
Declining to reach the merits because the case wasn't final while the property is already gone? That's a jurisdictional argument doing a lot of heavy lifting.
A separate guest post frames the legal theory more formally. A reader named Jason analyzes the situation under the fraud upon the court doctrine, citing Black's Law Dictionary. Fraud that seriously affects the integrity of the normal process of adjudication. Jason walks through Arkansas Rule of Civil Procedure 60C4, noting that a judgment obtained by fraud upon the court can be vacated at any time. No statute of limitations.
And there's a companion post, the one titled Stop Laughing, that makes the tonal argument explicit. This isn't a curiosity. It's a due process claim that deserves a straight face.
The Weaver post also flags a recusal issue. Attorney William Zach White's predecessor on the opposing side was Billy Jack Gibson, who later became a judge. Gibson is now presiding over criminal cases against the same former client he represented in the underlying property dispute, without recusing himself.
A judge hearing criminal charges against someone he once helped in a civil case against the person now raising fraud allegations. The conflict writes itself.
The Post documents the specific charges: assault, resisting arrest, failure to appear, criminal mischief, disorderly conduct, and public intoxication, all filed in 2025, all before Judge Gibson.
Due process questions have a way of multiplying once you start pulling the thread.
The through line across all of this is the gap between what the Constitution requires and what actually happened to one person's property in Arkansas.
When the appellate judges don't notice and the trial judge may have ESP, well, the next episode probably has more ground to cover.